Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, I know some of you have been geeking out on some of these videos that we've been doing here lately, which has been tracking some of the most important appellate cases that are happening on the national level as it relates to your Second Amendment rights. Now, there is a couple of other cases for my Washington viewers happening right here in our state that is directly attacking RCW 9.41.370, better known as Washington Standard Capacity Magazine Ban. Now, we have recently talked to Pete Serrano of the Silent Majority Foundation, who is the lead counsel in the matter of Brumback v. Ferguson. Now, that's the case that challenged Washington's magazine's ban over in the Eastern District of Washington. Well, listen, there's been some big developments, and he's been kind enough to share with us some of the new pleadings. So today, let's spend a few very exciting minutes and talk about, is this the beginning of the end for magazine bans in Washington State? Okay, so the case we're talking about again today is Brumback v. Ferguson, which is a companion case to Sullivan v. Ferguson. Sullivan v. Ferguson is filed in the Western District of Washington. Brumback v. Ferguson is filed in the Eastern District of Washington. They are both very similar cases in that they are challenging the constitutionality of RCW 9.41.370 enacted into law through engrossed substitute Senate Bill 5078, known to you and me as Washington's new magazine ban. Now, for those of you who've been seriously geeking out with us for a while, you know that you're beginning to understand how these big complex pieces of litigation work and how they move, or essentially how they don't move. Things move at a rather glacial pace. However, once suit is filed, then all the defendants either scream bloody murder about how they got the wrong people and they should be in or not in the suit, or other people try to jump in. Sometimes it's plaintiffs jumping in, sometimes it's defendants jumping in. But once we got all the parties clarified, then we move on to the next thing, which is what is some of the remedies that's being requested here by Miss Brumback, as well as the co-plaintiff in this case, co-appellant, which is Gimme Guns, over there in Eastern Washington as well. And we're going to put links down below for Gimme Guns and everyone else who's thrown their hat in this ring, stuck their neck out, fighting like crazy for your Second Amendment rights. Okay, so now that we got all the plaintiffs and all the defendants all figured out now in Brumback v. Ferguson, what's the next thing? Well, the appellants here, Mr. Serrano on behalf of Ms. Brumback and Gimme Guns, has now filed for a temporary injunction. So, what does a temporary injunction do? A temporary injunction is a big fat legal pause button, but it has significant effect because a court can order the enjoined party from ceasing to do certain acts. In this case, would be ordering the state of Washington to cease enforcing RCW 9.41.370. Now listen, Mr. Serrano, who was kind enough to join us for an interview right here on this video, was once again kind enough to share with us all of the pleadings that he has very diligently worked on and filed in support of the plaintiff's motion for a temporary injunction. And that is now currently set for oral arguments on November 23rd of this year. So we have a very important date coming up here in just a couple of weeks. Okay, and one of the big reasons that we all need to geek out and very carefully watch this is what is one of the tests necessary in order for the court to order a temporary injunction? Well, the plaintiffs must demonstrate that there is a likelihood that they are going to prevail on the merits. So in this case, Ms. Brumback and Gimme Guns must demonstrate to the court that they're asking for the injunction from that, hey, when you consider the merits of our arguments, we are likely to prevail. And we have seen this in other cases on a national level. For example, Vanderstock v. Garland, which is a challenge to ATF's new rules as it relates to unfinished frames and receivers. We have seen temporary injunctions being granted out of the Northern District of Texas, and that is an incredibly positive sign for that litigation. An injunction out of the Eastern District of Washington State would mean volumes and volumes of excellent news for the litigants who are trying to overturn RCW 9.41.370. Now, I'm going to share with you some small portions of the appellant's motion and a memorandum in support of the temporary injunction. But as usual, Mr. Serrano has written a really excellent brief here. But as we know, when New York Pistol and Rifle Association v. Bruin came down, the landscape for analyzing any Second Amendment regulation was significantly and forever altered in a very positive fashion. And so what you're seeing in a lot of these appellate cases, and you're seeing this in Duncan v. Bonta, you're seeing this in Bianchi v. Frosch, Hawaii v. Young, you're seeing this in New Jersey Pistol and Rifle Association v. Bruck, you're seeing it in Vanderstock v. Garland, and you're seeing it here at the local level, at the state level, in both Sullivan v. Ferguson and here again in Brumback v. Ferguson, is you're seeing very wise appellate attorneys start banging the Bruin drum as they should, because it is good case law, it is significant case law, and it does significantly change the landscape moving forward. Mr. Serrano was quick to point out, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. And this is in response to what the state continues to argue is, but we need these laws to save lives. And as we know, that was a plausible and rather effective argument when these appellate courts were still allowed to use that two-part balancing intermediate scrutiny test. But Bruin has done away with that once and for all. And so therefore, this policy position, no matter how valid it may be, if there is not a historical analog going all the way back to the late 1700s that supports this type of gun control legislation, it is per se unconstitutional. And what is so frequently the case in any time we're making these arguments about we need to do this to save lives, the data is usually sparse or non-existent. And again, plaintiff's counsel was quick to point that out here when they said the government cannot justify ESSB 5078's magazine ban legally or factually. The purchase, sale, and utilization of these prohibited magazines are protected by the U.S. Constitution's Second Amendment and Washington's Article 1, Section 24, as they are intimately connected with the use of legal firearms. The government's only justification for denying law-abiding citizens' ability to purchase, possess, sell, repair, etc. these magazines boils down to spurious claims of anti-gun activists that public safety is somehow enhanced. However, the ban actually makes people less safe. This justification by these activists, both in and out of government, while clothed in nobility, is a biased, emotional-based illusion devoid of fact. And that is exactly what the position is. Now, in furtherance of pointing out that, listen, there is a strong likelihood of prevailing on the argument because of the Bruin opinion, appellant counsel also pointed out, it should be noted that the Constitution protects the right to bear arms, plural, which means a few things of import. First, the right is not limited to the arms of the government's choice. The presumption in the law is that citizens, not the government, decides which arms are to be possessed. Second, the term arms is plural, which necessarily means the citizen has a right to possess multiple firearms of his choosing and, ostensibly, of various types, calibers, and capabilities. Third, the individual right is not only for personal defense, but also a right to bear arms in defense of the state. And that is really important because it says right in Article 1, Section 24 of the Washington State Constitution that we are to bear arms in defense of the state. Are they actually suggesting that we should somehow or another limit our capability of defending our state? And, of course, what the state does here, and we're seeing this more and more frequently, and that's why we've done a series of videos, because we're really beginning to read the tea leaves here and see the desperation that's coming out of all of these government attorneys here as they're arguing, is what they're saying here, essentially, is listen, there is a rich and lengthy historical tradition of these types of regulations. Now, the problem is they cannot produce any evidence or any example to support those claims. And the reason that history becomes so vital when we go back and we take a look at what types of restrictions are we in fact going to tolerate, it's because history also shows us that the Second Amendment did not grant us those rights. The Second Amendment merely codified rights that were inalienable to us and given to us at our creation. Counsel was very quick to point out, we look to history because it has always been widely understood that the Second Amendment codified a pre-existing right. The amendment was not intended to lay down a novel principle, but rather codified a right inherited from our English ancestors. And of course, the state also routinely argues, as they did here, hey, listen, when they ratified the Second Amendment in the late 1700s, they had no idea that they would ever create semi-automatic rifles, and so clearly the Founding Fathers did not mean to protect these types of instruments. Now, there's a very fatal flaw to that argument. Mr. Serrano points it out. It's an argument that all of you need to be familiar with, and it kind of goes like this. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment definition of arms is fixed according to its historical understanding, the general definition covers modern instruments that facilitate armed self-defense. And that is critical because, listen, we have a First Amendment, and guess what? It does protect us on Twitter, and it does protect us on Facebook to some degree, and it does protect us on our emails and all of that. We have a Fourth Amendment, and it does protect us from much more modern forms of search and seizure, which can be conducted now through electronic surveillance, digital collection, and things like that. But guess what? The Fourth Amendment still applies and protects us against that, despite the technological advancements that's been made in those industries. Why then would not the Second Amendment protect firearms in exactly the same fashion? The other argument that is being used quite frequently by government attorneys still trying to support these unconstitutional gun measures is that we do have a historical analog to restricting dangerous or unusual weapons. The problem for that argument is that we do not have a historical tradition of restricting dangerous or unusual weapons. We have a historical tradition of restricting dangerous and unusual. And the problem for all of these magazines from the gun-grabbing left is that there is nothing unusual about a 12-round magazine, a 15-round magazine, a 20-round magazine, a 30-round magazine. Many of those magazines are actually standard capacity magazines that are commonly sold with the firearm. And appellant's counsel correctly points out this is not about dangerous and unusual firearms. This is about everyday firearms. This case is not about extraordinary weapons lying at the outer limits of Second Amendment protection. The firearms deemed assault weapons are fairly ordinary popular modern rifles. This is an average case about average guns used in average ways for average persons. And that was a quote to the Miller case, which originally challenged California's AR ban, the principle, of course, being the same. Okay, so once again, the case is Brumback v. Ferguson. It's filed in the Eastern District of Washington, United States District Court. We're going to put a link for all of that down below. Now, listen, there's a couple of other things we need to be aware of. First of all, we have Gimme Guns over there in Selah, Washington. They have stuck their neck out on the line for this. They are a named plaintiff. They have put their entire livelihood up fighting for your constitutional rights. We're going to put a link for them down below. If you want to show them some love, please do so. Pete Serrano and everyone at the Silent Majority Foundation. Listen, these guys are absolute warriors. They are in the trenches. They are getting their knuckles bloodied for you every day, fighting like hell to win back your God-given rights. So if you want to show some love to the folks in the Silent Majority Foundation, we will put a link for that down below. The case, once again, is Brumback v. Ferguson. We'll put links for all of that down below so you can track it. And remember, the important date that they're going to be arguing for the temporary injunction is November 23rd, so just a couple of weeks out. In the meantime, if you have any questions about this case or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.